Good evening, all. Welcome to our another Tweaking Tuesday session that is particularly focusing on contract administration. Although this is at level 2, this is closely associated with contract practice that is covered under the core competencies at level 3. So the difference is here, the contract is being presented and then you are going to administer according to the contract. It's not like you are not going to do some advisory task within this contract administration. It is about procedures and the steps you have followed. So always whenever there is a question presented to you at level 2, you have to answer like what did you do when that situation happened at your site, or particularly the referencing summary of experience which is relevant to you. Although we are particularly focusing here about FIDIC 1999 Red Book, you may choose to refer to your bespoke or particular other form of contract that is familiar to you, because this is all about your summary of experience, nothing to do with the general knowledge and what is the industry using. So maybe in another countries like UK and all, JCT is more familiar and there are NEC, but in the Middle East mostly we are using FIDIC Red Book, and there are NEC also at certain extent, but the majority vast construction professionals use FIDIC for their construction projects, particularly the Red Book. So here the first one we are discussing about standard forms of contract. You are advising an employer on a traditional design project. That means it is traditional one. So what are the key administrative differences between using FIDIC Red Book 1999 and FIDIC Red Book 1987 concerning the role of contract administrator? Again, don't worry about being a contract administration means it is not particularly that you are from contractor or from the client. It is particularly about the engineer. So engineer's role is primarily considered to be the contract administrator role. Although every stakeholder, they have contract administrator for themselves. But here, when we are mentioning contract administrator, that is particularly representing the engineer. So what are all the difference between Red Book 1999 and Red Book 1987 regarding the engineer's role that is meant here as contract administrator? Anybody wants to try? No one? Yes, please, Shifat, you can try.
The FIDIC Red Book actually, since the design is already, the type of the procurement is the traditional.
Yes, yes.
So it is more preferable for the FIDIC Red Book, where the engineer rule, it will be like it will be like impartial. So whereas the design responsibilities will be intact with the engineer. Whereas in Yellow Book, it will be used to where the design and build projects. So engineer rule mainly in terms of the contract administration, it's mainly in favoring the contractor involved in terms of approvals, variations, and such.
Okay. So thank you for that. Primarily when we are concerning about contract administrator role in JCT and all, it is clearly mentioning about JCT standard building contract. It refers contract administrator or architect. But when we come into the FIDIC Red Book reference 1999 or 1987, it is only the engineer. So this engineer, earlier he was impartial. Even in JCT SBC also, he has to act impartially. But when it comes to FIDIC Red Book 1999, after which 2017 also there, the engineer is an employee of the employer. So he is working for the employer. Therefore, the determination is going to be fair determination when you are referring to subclass 3.15 these two subclasses referring to the role of engineer, that is giving only the fair determinator. It is not about impartial act. And you may refer to the new introduction of a dispute adjudication board, class 20, when it comes to FIDIC 1999 Red Book, since the engineer not impartial here. So there is another role that is coming into the picture, DAB. Okay, anybody wants to add something or like to discuss more? If not, let us move on to next question. Roles and responsibilities of parties. Under FIDIC Red Book, how would you, as the employer's quantity surveyor, differentiate between employers and the contractor's primary responsibilities regarding the works, and what is the key documentation that defines this split? Because this is about responsibilities of the employer and the contractor, how it is splitting up. Anybody wants to try? Okay, here the primary focus is to understand the contract type. Here it is the employer primarily responsible for providing the design of the Red Book because it is employer designed. That means the design has to be provided by the employer and the site access. And when it comes to contractor, primarily responsible for the execution and completion of the works and temporary works and overall site safety and methods of construction. The core defining document for the scope of works are the specification and drawings. So these are the things you will verify when you want to identify the primary responsibilities of the employer and the contractor. Okay, let us move on to next question. The role and responsibilities of contract administrator. Describe the practical steps you, as the engineer under FIDIC Red Book contract, would you take if you intended to delegate some of your duties to your assistant. So this is practically how would you do. So this is about engineer as the contract administrator. Anybody having some idea about this? Do you want to try? Okay, here main focus is about implementing. Yes, please. Yes, Mr. Moyo. Yes, you can go ahead. Do you want to try?
Yeah, I can try. I think.
Yes, please. There was some breakage. Okay, it is fine.
Scenario. Okay, can you hear me?
Yes, now it is clear.
Okay, yeah. So if you are to distribute some of the responsibilities, I think you distribute the responsibilities, but at the end, before any documents are issued out, they will need to be reviewed or authorized by you as the contract administrator. For example, if you're to assess an extension of time claim, you will delegate some of the work to maybe your assistants. You can give them that. But the ultimate saying, the ultimate approval and authorization has to come to you for this was the information which was provided for an extension of time. This was the substantiation, and this is our, the contract administrator's determination in this case. We either approve or reject the extension of time and give the reasons why. The ultimate role for the contract administrator in this case is giving the authority to issue those documents to the contractor. I hope this is what you meant by the question, meaning distribution.
Yes, of course, because you have to consult with the employer and it has to be then notified to the contractor. So that has to be clearly defined by steps, like as you said, that is correct. Very well explained. Thanks for that.
Okay, so you say, if you want to distribute, even if it's your assistant, it has to be communicated to the employer first, and then you also communicate to the contractor. To the contractor, yes. Is it necessary, or is it as long as it's the same company, or does it have to be a named engineer?
Yes, thank you for that. Anybody wants to add something or try in your way of explanations? Okay, let us move on to next question. Coordination of parties. A key instruction needs to be issued that affects the work of two different subcontractors and requires a change in sequence. How do you, as the engineer always here the engineer means it is the contract administrator. Ensure proper coordination and formal communication of this instruction. Even if you are representing contractor, when it comes to subcontractor, of course, the contractor's responsibility also being the same, because here they have to get involved both the subcontractors that is affecting the work. Therefore, there is a change in the sequence of the work, how they are going to coordinate. So this coordination of parties, how do you ensure proper coordination and formal communication of this instruction? Anybody wants to try? Okay, here the primary focus is to implementing the instruction and coordination procedures. Now formal instruction you would given to the contractor. The instruction must also be clear with detailed and the required procedure from the contractor to implement the necessary changes and coordination. So how they are going to propose, that relies with the contractor. The contractor is responsible for coordinating all parties on site, including subcontractors. The engineer does not issue instruction directly to the subcontractor, because anyhow the work sequence is the responsibility of the main contractor. So you may not involve instructing directly, even though they are nominated or named subcontractors. You would not do that directly as an engineer to the contract. So an engineer does not issue instructions directly to the subcontractor. The contractor would be proposing how he is going to implement the change in sequence and coordinate between the subcontractor. He will arrange for the necessary coordination meetings. Maybe if required, that will be done in the presence of engineer. Otherwise, the report minutes, recorded minutes of meeting would be distributed to the engineer and the employer. Okay. Let us move on to next question. Yes, anybody wants to add something here?
Yeah, I think the engineer will review the revised program and ensure the milestones are achieving, right? I mean,
Yes, yes, of course. Yes, that review would be there, because whenever there is a proposal by the contractor, you have to make sure that is. Thank you. Thank you for pointing it out. Let us move on to next question. Design coordination. So earlier we have seen coordination of change in sequence of works. Under the FIDIC Red Book, the design is largely provided by the employer. If the contractor identifies an error in the employer's design drawings that impacts the safe execution of the works, what administrative procedure must the contractor follow, and what is your resulting action as the engineer? So anybody wants to try? Yes, please.
Contractor has to immediately notify the error to the consultant,
yes,
to the engineer,
yes,
written, so that the engineer have to look, and it has to be recorded, so that for the EOT this may need to substantiate the delay.
Yes, because whenever there is an error, identify the contractors. So once the contractor getting aware of it, he has to notify the engineer immediately upon discovering the error, because the class 1.8 and the class 4.10 site data, these things, whenever there are errors, it has to be intimated by notifying.
Exactly.
And then the engineer has to take action promptly to review the issue and issue necessary instruction to correct the design error. Either if it is practical and the contractor is capable enough to do that, then he can instruct to asking proposal from the contractor himself. Otherwise, he will be instructing to the design team to correct the error and reissue. And if this instruction continues to have some impact, like variation or time impact, then that has to be followed by the procedure of issuing change order or variation procedure under class 13. Because if it only impacts the safe procedure only, then it is fine. There won't be any cost or time impact. Otherwise, it has to be dealt under the variation procedure. Anybody wants to add something? Okay, thank you. Let us move on to next question, which is about planning and building regulatory controls. What administrative steps must the contractor take to ensure compliance with the relevant permits, licenses, and statutory obligations as required by the contract? And how do you monitor this? So it is implementation of legal and statutory compliance.
That is mandate.
Yes.
And I think that is mandate, and it can be monitored by keeping a record. I mean, a log of with the status, and it has to be
Yes.
updated periodically. I mean,
Yes, for the execution of work, generally the contractor is responsible and he will keeping the log and update it for all the permissions, licenses and approvals required for the execution of works, not for the design. It is for the execution of works. It is compliance with the laws like class 1.13 and class 4.18, protection of the environment. As the engineer, so the contractor administrator shall monitor the records of the contractor through the progress meetings and instruct anything proactively if required, or if required for any further coordination between the contractor's program of works for key regulatory milestones. Because if you are having something within your milestones, then that will be helpful to monitor and control the required official approvals or permits. Anybody wants to add something? Okay, thank you. Let us move on to next question. It is about health and safety. Describe the steps you would take if during a site visit you observe a significant immediate threat to health and safety that is a clear breach of the contractor's obligations. So it is not something like you would expect from health and safety mandatory competency that as a safe, because the safety is the responsibility of everyone as a quantity surveyor or contract administrator. Also, if you go into the site for some visit and you find something, that is different. But here it is clearly a breach of contractor's obligation. In that case, what would be the steps you would follow to correct this? Anybody wants to try?
I think the notification has to be raised for the for such a breach of obligation.
What sort of notification? That is the key. Notification, yes, of course, notification. But what is that?
Notification to suspend the works.
Yes, that is important. They have to clearly cease the work because it is particularly breach of contract and their obligations. So you have to cease. The work has to be suspended until or unless it is corrected. That formal instruction with the notification you have to issue. That is the immediate thing we have to do, and we have to require the contractor confirming the remedial action, and particularly the way how we will verify the rectification by doing monitoring and control. So that is important. Anybody wants to add something?
How long do they have to rectify or to correct the issue? Is there a timeline for that under FIDIC 99?
No, not exactly actually, because this is breach. So you can ask something like immediate recovery. It is not clearly defined that what is the timeline. So you can ask for it, and then if at all they are not implementing the remedial measures to your satisfaction, you may go for some sort of notice to correct under class 15.1. That will make potentially a default from the contractor. So then you have to deal in that way. So directly from this point, you don't have any specific time limitations. Anybody wants to add something here? Mr. Sifat?
No, nothing. I just want to understand, like, if there is some severe breach of contract obligation. So is that the case? Like, directly the contract? I mean, in terms of health and safety, the contract can be terminated as well.
No, this is again, you have to go, if you want to take it to the
Case by case.
termination, it is case by case, how severe it
Case by
is.
case.
You
Yes, yes.
can
How severe?
do by others and back
Mm,
charge them. Or else if
yes.
you want to take it to the termination, yes, of course, you have to go to the
You can do.
15.1 and issue the contractor
Yes.
fails to carry out any obligations. So that is their
Exactly.
notice to correct. And if they are failing, that is also again it is telling reasonable time. So it is not clearly giving time. And
So in
then
such
you will
scenario,
go, yes.
yeah. So in such scenario, I mean, the contractor will not be entitled of time, right? I mean, EOT, it cannot be granted, right? I mean, if say for example, if at site asbestos found and then we stop the work, since it has to be taken out from the laboratory and it has to be cleaned. So say 60 days delayed, 60 days the project is completely suspended. So following that, so contractor entitled to
No, he is not
get the.
entitled. He was in breach of contract that particularly from his
Mhm.
obligation to maintain the
Right.
site safely.
Yes.
So that is not
Okay.
there. So he is not entitled.
Okay. Yeah. Just to get more clear on that.
Okay.
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 Good. Good. Thank you.
Thank you. You're welcome. Let us move on to next question. Monitoring progress. The contractor is consistently behind the program submitted under class 8.3. How do you implement the procedure for addressing this delay and what certification must you issue? Anybody wants to try? So this is implementing delay progress monitoring and certification. The primary focus. The engineer must issue a notice to the contractor to submit a revised program or a recovery program. That is the first thing the engineer usually do. As a contract administrator, you would do the same thing, asking for a revised program or a recovery program. That would have an updated description of the methods to be adopted to expedite. That means it has to be mitigating the delays without any acceleration or something. So this is under the program. And when you go for rate of progress, if the delay continues, the contractor fails to achieve the time for completion. The engineer must issue a notice of failure to complete. So that will come in case of any milestone delay or fails to complete on time. So that is there. That is prerequisite for the employer to claim liquidated damages. So you have to have this recorded. Otherwise, you would not be able to claim in favor of employer any liquidated damages. Okay. Anybody wants to add something or clarify?
The last what certification that means must you issue in that case? What kind of certification? Certification is what here?
No, certification is the thing that how the contractor rate of progress, that is the
Okay.
thing is whether it is acceptable, that it can be used to mitigate the delay or not. Because whenever they are submitting the revised program, so based on that, you should be able to recommend to the employer that the revised program is feasible.
Okay.
So that kind of recommendation is understood here as certification. It is not about
Okay.
any payment or
No.
something
Yeah.
as
This is
the
what I was
performance
confused.
certificate or something. It is
I
not that.
confused with that. I
It is
got
about
confused with that
the,
only.
yes, yes. Okay, thank you. Yes, Mr.
Thank
Amit, you want to add something here?
Not now.
Okay, thank you. So next question is about monitoring quality. The engineer has requested an inspection of a key element of the works, like concrete pouring. So the contractor proceeds without the inspection. What is the contractual recourse for the engineer and how do you document this? Because concrete pouring, usually in our area of practice, the engineer has to witness and see the preparation is good, and during the pouring also he has to verify some of the concrete quality verifying procedures. So in that case, if contractor proceeds without the inspection, that means engineer was not there, Anybody wants to try? Okay, this is about implementing quality control, particularly non-conformance procedure. So here we will refer to the subclass 7.4 testing, 7.5 rejection, because the engineer should issue a formal instruction to the contractor to open up and test the works at contractor's risk and cost, because he was not there. Now the work has been executed. Now it is something like you have to go back and do the test record to make sure that the work executed is as per the required standards and quality. So now this cost will be contractor's risk and cost, because he literally breached the contract by not waiting for the engineer. So this will be recorded by the contract administration, like record the breach, particularly in the minutes of meeting also you have to discuss and record it. If the works are found to be non-compliant, again, they must be rejected and removed, remedied. So they have to remove the work and make it good at the contractor's own expense. The cost will be contractor's responsibility, even the delay also, because this is breach of contract. So it will be recorded in that manner. Anybody wants to add or clarify?
Excuse me. Today,
Yes, please.
Today I joined with this discussion. So it is mean that NCR or SOR, whatever the engineer is using the format
Yes.
for the.
Yes, of course. That is the one you have to use for the non-conformity of the works, and you would record. Yes, please.
It is basically with the quality and aligned with the specification.
Yes.
Am I correct?
Yes, yes, of course. Because you would refer to the specification, what is the required standards or quality of the work executed without the witnessing of the engineer. So this is about the quality, monitoring the quality. So it refers to the particular specification and standards in extent which is covered under the contract documents.
Okay, thank you.
Welcome. So let us move on to next question. It's about insurances. The contract data requires the contractor to maintain works, plant, materials and equipment insurance as per class 18.2. How do you administratively confirm that the contractor has complied with this requirement at the commencement date? So now the question is whether the contractor has complied or not at the commencement date itself. Anybody? So this is about implementing the insurance verification. Our focus is to verify the insurance. The contractor has to submit the evidence. That is the requirement. So then we would go in detail about the coverage, deductibles, those kind of terms. We would refer and verify all insurances to the employer for the review before commencement date. So that is the standard requirement, like 18.1 general requirements of insurances and 18.2 insurance of works or for works. As the engineer, so what we have to do, we have to verify these documents or in place. That means you would have submitted before the commencement date. If they are there, we have to verify to the requirements in accordance with the particular conditions, because particular conditions you would add details for the particular details of insurance coverage, deductibles, or under whom, how it refers to the employers as a primarily insured. Those kind of details should be there. And appendix to tender. So those records also, it is important. What is the value of insurance? Those kind of details you would refer to these documents and confirm to the employer that the evidence is satisfactory. If it is not, we have to issue again notice to the contractor to submit at the immediate effect. Anybody wants to add something or clarify?
Generally, I think there is some timeline now after, before commencement date, it means I think after issuing the LOA or the contract, say I think within 14 days, or is there any timeline in clause 18.2?
No, this is 18.2 for the work. That is particularly, it has to be there before the commencement date. So it is not particularly asking any timeline other than that. So there are no
Okay.
references to the time because it
Okay.
is before commencement. So it should be there. So
Okay.
before commencing the works at site, he has to submit these things to the employer.
Okay.
Thank you.
Thank you.
Let us move on to next question, which is about bonds parent company guarantee. The employer is entitled to a performance security. Detail the steps you would take to ensure this security is in place and maintained correctly under the FIDIC Red Book. You can refer to your own form of contract, that is fine. Anybody wants to try? So similar to the insurance, here you are verifying the performance security. How do you verify?
Yeah, and again, the expiry date, it will be recorded in the payment IPA, IPC, so that it can be tracked, just to make sure that it is valid.
Yes, that can be done to monitor and verify
Verify.
whether this is there or not. And first, when you are checking anything is there.
Yeah,
So
I think,
usually, yes, please.
yeah, I was going to say for performance security, there's a few things that need to be in place, and one of them is if the contractor is able to provide, the performance bond, which is to the amount stated in the conditions of contract, in the particular conditions. For example, it could be 10% of the contract sum
Yes.
for a specific duration of time, which is usually, for a performance bond, maybe until the end of the DMP period. So when you receive your tender returns, it's to be confirmed, or before contract execution, we need to make sure that it is 10% of the signed contract, and also the duration as well. If the contractor is not able to supply this, maybe the employer may be willing to accept such bonds as parent company guarantee. They'll be able to accept parent company guarantee instead of a performance bond. In other mechanism, maybe the contract, the employer may be accepting a bond for retention as a source of performance security. There could be that as well, and just make sure that it's valid, correct date for the correct project. And in other instances during tender, the client may provide the contractor a template, the form in which they can use to obtain some of these performance security, usually the specific bank, the specific wording, and so forth. So you can check that this is as was issued and is required under the contract.
Yeah, and in addition to
Thank
that,
you for
I
that.
think
Yes, please.
yeah, in addition to that, the key area that on demand sometimes or conditional type
Yes,
of
conditional,
bond, what is the
unconditional.
requirement,
Yes.
that is that has to be properly checked. What is the requirement of the employer, so that it is in line with that.
Yes. So, and one more thing, in the FIDIC Red Book 1999, the insurances are required to be presented before commencement date. But here, once the contractor receives letter of acceptance, he has 28 days. So that should be the timeline for this. Thank you for that. Anybody wants
Thank
to
you.
add or get clarification? Okay. Let us move on to next question. Third party rights. The contractor's operations cause damage to an adjacent property. Third party. Describe your administrative role in this scenario, differentiating between liability and process, because he is damaging adjacent property. Yes, please. Yes, Mr. Moyo.
Isn't this covered under the third-party liability? The contractor should have the necessary insurances in place, don't they, when it comes to
Yes,
this?
of course.
So I think when it comes to that, our administrative role is to make sure that appropriate insurances are in place. And when a complaint or a claim has been received, it can, I think the engineer in this place is to monitor the process and to make sure that
correct insurances, correct documentation has been provided by the contractor to whoever is complaining. But in terms of third-party rights, this is usually specific to the UK, isn't it? I don't know if it's very common in the GCC.
Yes. So that is the case. So as an administrative role, you have to monitor the contractors because he should be having the third party insurance in place. So whenever there is an instance, he has to make investigation report of the extent of damage that has to be verified. He is recording those things to the insurer clearly, and it has to be get agreed from the third party. It should be in the presence of the third party also, and they ensure the contractor make sure further damages would not happen in future. So he has to make sure why it happened, the root cause, and he should submit some remedial or proactive measures that should not repeat in future. So why it happened and how he is avoiding that thing in the future. So all these things should be documented and kept as the record within the project, because these are things are considered to be records of facts. It's not going to be something contractual, but still, since the third party, the adjacent property owner, going to be the neighbor of this premises, so all the records should be there with the employer as well. Okay, anybody wants to add something or clarify? Okay, let us move on to next question. Payment provisions. Detail the step-by-step process you as the engineer would follow to determine and issue an interim payment certificate under class 14. So it may be, it is Red Book 1999, so class 14. You may refer to your own form. Anybody wants to try? It is about interim payment.
Yeah, I will try.
Yes, please.
As a consultant keywords, first I will check as a consultant keywords, I will check the first contract provision about the valuation, interim payment valuation. What they have mentioned, what are the date to submit the draft payment, then what is the final payment, interim payment, I'll submit. Then accordingly, I will advise to the contractor submit as a draft payment for every month of 26th. Then I will check the first once I receive the payment from the contractor, I will check the first I'll check the insurance validity of the all insurance and bonds. What are the validity still valid or not? I'll check. Then I will check the WIR report. Accordingly, I will check the measurement sheet, which is the contractor measurement sheet, which is the what are the previously approved payment and what is the present and what is the cumulative. Then I currently link with the BOQ, whether the properly link the BOQ, arithmetical error, everything I'll check. Then I will check the material on-site and off-site, whether they claimed any material on-site, off-site, and previously they claimed this time they adjust the material on-site, off-site in the BOQ or not. I will check that also. And if there any penalty or any KPA deductions or any subcontractor payment, direct payment is there, something that also I will check. Then I will check the supporting documents such as the drawings and approved WIR report. Is there any, what are the WIR report mentioned in the code A, code B, code C? Then what is is there any overvaluation is there, which is the contractor sometimes they claimed, which is forecast payment also they will submit. Then I'll prepare then I'll check the gross summary, which is the including the preliminaries. I will check the preliminaries also, which is what are the contractual requirement, which is insurance. They submit the claim all the insurance, and what is the method letter charge also I'll check. Then I'll check the gross summary, which is covered in the all bills. Then what is the period ending time? Then I will check the deduction of advance payment, recovery of the advance payment, deduction of the retention, or if anything other deduction also. Then as a consultant, I'll prepare the payment certificate. We have our own format in the payment certificate. So I will whatever the gross summary, I will transfer to the payment certificate, which is the previous certified payment, present one. then deduction, total deduction and current retention, total retention, then advance payment, and what is the valuation of work. So everything I'll prepare, then I'll submit to the client for their approval.
Yes, that is fine, because all these records, whichever we have, that is the amount less than the contractor's applications. So those details should be included in the payment certificate, like what are all the particulars of the conditions that are applied to those differences, because they would have claimed, as you have mentioned, they claim something work on progress without any work inspection or material inspection. Those kind of things still needs to be certified. Okay, thank you for that detail. Anybody wants to add something here? Okay, let us move on to next question. Change procedures. The employer wants to add a new element of work, because the element itself, it is new, that is not in the contract. How do you formally instruct this as a variation, and what contractual right does this trigger for the contractor?
So can I try?
Yes, please. Yes, please.
Yeah. So the engineer can issue. The engineer can go for a change request where they will ask the contractor to propose a cost and time impact for that change. And once this has been received by the engineer is then to look at it and then will review. And once it has been agreed, the engineer will then issue a formal instruction to the engineer requesting or in a form of a change order, a variation order, where there's a cost, time impact, and it will detail the changes that have been issued. And in many cases, it may also be described what other impacts, what other things may have been impacted, which has been raised by the contractor. For example, maybe a facade change can also trigger other things within the structural element that will also be detailed within the variation order. So yeah, that's the process really. And then it will obviously be documented in the engineer's change order, list
Approval procedures. Yes, please.
With an approved or pending or whatever status it's in at that point.
Yes. Yes, Mr. Gautam, you want to add something?
That question is like from consultant side, I have to explain, right?
Yes, this is usually contract administrator. That's what I said. Here, as per the FIDIC, we are considering this is as the consultant point of view. So this engineer who is supervising, he is the contract administrator here.
Yeah,
so
yeah, understood. Yes.
if you have different nature of duty, you can explain that and you can approach from your viewpoint. That is fine.
Yeah,
it is not like
yes,
this is the thing everywhere. It is universal.
Because
like
usually in my bespoke contract, when client want to add some client want to give some additional work to the contractor, first we as a consultant QS, we received from the client for the business proposal. As a consultant, I will prepare the high level cost estimate. Then I'll submit to the client. Then based on that one, client will verify whether within this budget or not, they will verify. So if it is within the budget, the client may request then I'll prepare the change request form as we have a standard template. So based on the change request form, client will issue the site instruction, which is in FIDIC, I think it's an engineer instruction.
Yes.
So once engineer instruction issued, I will forward to the contractor. Within 14 days, contractor has to submit the TAM impact and cost impact. And cost impact, as a commercial team, I will review the cost impact, which is the using the quantities, all the quantities as per the drawings. Then they use the BOQ existing BOQ rate or any rate derived from the existing BOQ or any new item, any completely new item rate, such as the method used for the first principle method.
Yes.
Then I will check the quotation, which is the submit the 3 quotation, minimum 3 quotation has to submit. Then I will check the all quantities. I will check the all quantities. Then I will do my independent assess. I will do my independent assessment also. Then I will compare the contractor rate and our rate also. So then I'll submit to the client. Then the client will approve the rate. Once approved the rate, then I will, as we have a VO form. So I will prepare the VO form. Everything I will include all the what are the site instruction number, what is the VO number, what is the work description. So what are the changes? Is there any time changes or contract amount is changed? I will mention everything the VO form. I mean the VO variation order form.
Yes.
Then I will give. Then I will get signature from the. I will get acceptance and signature and stamp from the contractor. Once contractor stamp, then I will in my consultant side. We are the sign and stamp and sign. Then I will forward to the client to get their approval also. So when VO is formalized, then contract amount has been changed. So once contract amount is changed, the contractor is entitled for the payment for this variation order 100%.
Okay. Thank you for that. It is very well detailed. Let us move on to next question. Sectional completion or partial possession. The employer wishes to take over a completed distinct part of the works. Before the whole is finished, what certificate do you issue and what are the key consequences of this action for the contract? This is what it is. It is a sectional completion or partial possession.
I think.
Yes, please.
So the sectional completion and partial possession are generally similar in the way they are issued. They work, except sectional completion is pre-planned, whereas partial possession maybe is not planned and usually you have to agree with the contractor.
Yes.
But once it's been agreed at that point, a taking over certificate should be issued, taking over notice should be issued for that proportion of the works. And once that has been determined or completed, what would then happen after that is retention in proportion of that sectional completion. Half of the retention for that part needs to be released at that time as well. And generally, insurances for the contractor that were usually covering that portion of the project will now be transferred or will be stopped, and they will now be under the contract, the employer's insurance. And if there was any performance bonds and so forth, they'll also they need to be adjusted to the end of DMP period for that section. And any defects liability period also for that section will start at that time of completion, usually 12 months after that TOC.
Yes. When we are referring to the FIDIC 1999, it says something about 2/5, 40% of the portion.
Yeah, we actually.
Correct.
Sorry.
Yes. Yes, Mr. Gautam.
Yeah, actually the sectional completion is it's already stated in the contract, such as a key stage completion or milestone completion. Partial completion is when client wish to taking over some parts, that is they providing the partial completion. So they giving the taking over certificate. So as per the contract, contractually, if the taking over certificate is contractor received, they are entitled for the 40% of retention as per the contract. So the contract is entitled for this retention. Then accordingly, they can adjust the performance bond. They can adjust on the performance bond also. Then once they complete the whole work, the client will issue the whole completion certificate.
Yes. Okay. Thank you for that. Let us move on to next question. Nominated or named subcontractors. You are administering the procurement of a nominated subcontractor. What formal administrative procedure must you follow regarding the nomination? And how does the nominated subcontractors delay affect the main contractor? Anybody wants to try? Okay, so when it comes to the nomination procedure, it is for the risk allocation. So we can refer to class 5 if it is FDIC Red Book 1999. The nomination procedure, engineer issues an instruction to the contractor to employ the nominated subcontractor, where the details are already discussed with the nominated subcontractor, like proposal, agreed with the employer, those kind of things. It can be forwarded to the contractor to discuss further to conclude the subcontractor and any conditions between them. That is up to the contractor. So it will not detail in such level, but what is the primary proposal that would be given to the contractor. So if nominated subcontractor he is causing the delay, the main contractor is entitled to claim an extension of time and cost if the delay is deemed a cause for which the contractor is not responsible. It is clearly the nominated subcontractor's responsibility. He is culpable and clearly demonstrated by the contractor and reviewed by the engineer. Then the contractor becomes entitled to claim on EOT and cost. So engineer must process this as a claim under the clause 20.1 and make a fair determination. So whatever it is. So it is fair. Again, it may go to DAB if what all it is not agreed. But as per FDIC 1999 and later editions, the contractor may get EOT and cost for the delay is purely caused by the nominated subcontractor. Anybody wants to add or clarify here? Okay, thank you. Let us move on to next question. Extension of time, loss and expense. The contractor submits a claim for an EOT and cost due to late access to the site, which is employer's risk because the access has to be provided by the employer. It is employer's responsibility or obligation under the contract. Detail the administrative procedure you as the engineer or contract administrator must implement to assess this claim. What are the things you would look into when you are reviewing this claim for an EOT and cost that is due to late access to the site? That means commencement was delayed.
Okay,
Yes, Mr. Yes, please.
Yeah, when it comes to the later access, the first thing I'll check is when I'll look at the program first. On the program, it will indicate when access was meant to be, when contractor was meant to go on site. And then I'll also see when the actual site was possessed by the contractor. And then I'll also look at the contractor's substantiation of why they determined this amount was, is due to them. For example, the amount of prelims or any other charges in terms of overheads that they need to, that they are they may be claiming. So these are some of the things that I'll be looking at as well, and how much time. I'll then review this with with the planning engineer to see if there was any time impact, and also if there's any way of if the contractor has submitted anything in the way of ways of accelerating as well. These are some of the substantiation that I'll be looking at.
Yes. So if you are familiar with FDIC 1999 or any specific contract, you can also mention about the time requirement, like 28 days. Within 28 days, he has to give notice, and within next 42 days, he has to give the detailed claim. So only those things can be added here. Anybody wants to add some more or clarify? Thank you, Mr. Moyo. Let us move on to next question. That is material on or off site. Under what conditions can you, as the engineer or contract administrator, certify payments for materials intended for the works that are not yet incorporated? And what measures do you implement to safeguard the employer's interest? This is about materials on or off site payment. What is the procedure you would follow to certify that? Yes, please, Mr. Moyo.
I can try again if no one else wants to try.
Yes, please.
No problem. So I'll start with the material offsite. So the first thing I will check is if there is a contract provision within the contract for any offsite or on-site payments. If there is, if there's no provision, then I can I can talk to the client. Maybe we can trigger a contract amendment. But if it is there, that is fine. Then I'll check if the material, which is which the contractor is claiming for, is listed in the contract, because normally they'll have to list some of these things that need to be,
yes,
paid on site. And then if it is there, that is fine. I will also then check the program if the material is falling within the acceptable part of the program, because sometimes it's a 4 year project. There's no need to be purchasing or client to be paying for material that's material that's to be executed towards the end of the project. So I need to make sure that it's falling within the right program. Once this is acceptable, I will then check if there is any proof in terms of maybe there's a vesting certificate needs to be in place, or any invoices, receipts, or anything of the like, and make sure that insurances are in place, is correctly stored somewhere or protected, and then we'll pay for that according to the contract. Sometimes there's a set or maximum amount that needs to be paid for material offsite. It might not be the full amount,
yes,
maybe a percentage, and we'll then pay according to that. Sometimes it's like a ceiling level, and that's what we'll do. When it comes to the material on site, we just need to make sure that the material has been designated and has been received within the contract. Is called on site. It's usually within the contract. It's been protected and clearly labeled that it is for these works that needs to be done. And the correct quantity, again, it will be paid according to the contract as to how much will be paid. There's a percentage that will be paid, maybe if it's not amended, maybe it's 40 or 60 or 70. It depends on the contract. You just need to check that. Again, the same amount for the, within that correct amount of program and the like. You don't necessarily need a vesting certificate for this one because it's within the client's site.
Yes. Thank you for that detailed answer. Anybody wants to add something from your contract or from your experience? Okay. Thank you. Thank you, Mr. Maya again. Let us move on to next question about determination, because this is the term that is usually brought into picture whenever there is no agreement reached between the contractor and the engineer or contract administrator. Then what sort of thing, like a contractor has failed to comply with a notice to correct a serious breach of contract. So already there is a breach of contract. As the engineer, what administrative action do you take to allow the employer to proceed with the determination of the contract? Anybody wants to try?
If contractors having some performance issue and the engineer sent to the notice to correct the letter to the contractor, but still not taking any corrective action and recovery program something. So our first course of action, I will advise to the client to make a penalty to the contractors for this any breach of the work or performance delay in that any delay. Then if it is still same continuing the performance, then I will advise to the client to terminate the contractor.
Because the delay penalty and termination before the time for completion. So these things, unless you have specific milestone proportions or sectional completions are in place, how would you advise on applying the delay penalties or delay damages?
The delay penalty in my contract, we have a delay penalty for each completion, each delivery bill. For example, any penalty for the HSE violations and penalty for the sectional completions. So we have a penalty for the per day penalty, which is 100,000 per day, and thereof
Thank you for that, because you have to clarify that. Otherwise, the assessor may not understand from what basis you are bringing in delay penalties before the completion date. So that should be clarified. Yes, Mr. Moyo, please.
Yeah, I was going to say, normally when to advise the client, there are certain steps that you need to do if there was a breach and the contractor is not complying with it. The first thing what I'll do as a contract administrator is you review the non-compliance. So in other words, you just confirm that the notice was issued and it was valid from this date to this date. You verify that the contractor has failed to actually do or make any action. They didn't correct anything. And then what you do after that is you then prepare a determination report. It's usually to the client where you advise them, and
Yes.
Normally this report, you include things like, okay, this is what happened. This was the breach. This was the timeline. These are the evidence. Maybe there's pictures. Maybe there's email evidence. And that the notice was not followed, and you then put a recommendation on it. Sometimes it could be a letter, it could be you recommend termination. You submit this with a written recommendation. You use your clause, usually clause 12. You attach all the supporting evidence and everything. What you do is you then help the employers notice. You kind of like help them with the termination. If they've decided to proceed with the notice and things like that, you kind of like reference these clause, the date, and so forth.
Yes. Thank you for that. Let us move on to next question. Yes, Mr. Godam, you want to add something?
No. Let's see.
Thank you. Yeah. So next one is liquidated and delay damages. The contractor has failed to complete the works by the revised time for completion. That means there is an extension EOT for any other reason, but there is a revised time for completion that is also not met by the contractor. What is your role regarding the imposition of liquidated damages, and when can they no longer be imposed? Two things. What is the imposition of liquidated damages? How would you apply it? And when can they no longer be imposed? At which point? Yes, please.
Yeah, liquidated damages will be applied as soon as they're late. So from the day they're late. So the day after when the extension of time was due to be given. So at that end, so you can't apply it from the initial date, but from whenever it was determined. And then it can no longer be imposed if it has reached a certain limit. Maybe there's a certain limit as per the contract set, usually 10% of the contract price. It has reached the ceiling level. You can no longer add an additional amount.
Yes, that is correct. Anybody wants to add something? Because usually we used to refer this as a time at large. That means you can't do anything to control the contractor after this point because you have reached the cap imposed on the LD. So you have applied all those things. No longer the contractor is liable further, and then we have no control over the time now.
So in that case, we cannot terminate, and the employer can terminate, and they can appoint the contractor to.
Yes, you can go if it is further getting delayed and all those things are there. Yes, of course, but you cannot control the time now. There is no imposition of time limit. So already it is reached to the maximum cap.
Okay. Yeah, that is there.
Okay, thank you for that. Let us move on to next question. Completion. What criteria must the contractor satisfy before you, as the engineer, can issue taking over certificate for the works? And what is your procedure if the works are substantially but not perfectly complete? Yes, Mr. Godum.
Yeah, when I give a taking over certificate, okay, first before the taking over certificate, as a quantity survey and I will under engineer, I will verify I will visit the site myself and I will verify it whether everything is completed and what all NCR is clear and all WIR is clear, everything is clear. I will verify myself. Then if it anything pending work is there, like a kind of minor work. So if then I will discuss with the client. If client it is okay to can issue the taking over certificate, means I will issue the taking over certificate and also I will add in the snag list in the minor work, which what are the quantities for that work and what is the amount for this work. So I will mention the taking over. So during the maintenance period, the contractor should complete that snag list work.
Okay. So what about this? What is the imposition of taking over certificate now?
You can give a certain time, can you? You can do a conditional taking over certificate where you require a certain amount of time to be to rectify any issues.
Okay.
Is this not it? Because when it comes to the criteria,
now the term here mentioned is because yes, it is fine, but here two terms are used. One is substantially complete, but not perfectly complete.
Yeah, substantially complete means the client can take over the site and they can use it, and the contractor can fix any snagging or any imperfections without disrupting the functionality of the building. So as long as that's suitable, for example, maybe there's a little bit of painting that's in the toilet, you can still carry on using the building for the main function, but it can be done on the side without disrupting the whole building. So in that case, you can say it has been, the client can take over. It is now practically complete.
Yes, that is the thing we have to clarify here, because it can be used by the client without any functional inability. So that is the thing is called substantial. It cannot be like until or unless the defects notification period is over, we are not sure that it is perfect, because many errors and problems that may surface later. So perfect is something different. So substantial completion is what required to issue the taking over certificate. That means the client can take it over and use for the intended purpose without any functional inability. Thank you for that, Mr. Moyo and Mr. Gautam. Let us move on to next question. Defects rectification period. A defect is observed 1 month into the defects notification period. What administrative steps do you take to ensure the defect is remedied, and what is the final document that concludes the engineer's duties regarding quality? Yes, Mr. Gautam.
The end of the defense notification period, then the client will provide the maintenance certificate or performance certificate. So once performance certificate is issued, the contractor can submit the discharge certificate along with the final account. The discharge certificates can mention this is the final amount for in this project. Here after we will not claim any other this discharge certificate amount.
Okay.
Not sure it's correct.
It's fine, because this is about the what we can say. Of course, you are mentioning about the closure, but what is there like for the remedying administrative steps to be followed before going to the final performance certificate or discharge letter, all those things?
You need to
during the defects notification period, you identified a defect. Now, what would you do?
That I will inform to the contractor to rectify the defects.
You have to notify to the contractor.
Yeah, to inform to the
remedying the defect.
Yeah.
So within reasonable specified time.
Period. Yeah.
No, not before the period. He has to do within the reasonable specified time.
Within the reasonable
time. So that is important. If he fails, then you have to remedy the defect by a third party contractor or subcontractor, and you may back charge or this failure to remedy the
retention amount.
Yes, these are the things are necessary to hint here in this particular situation, and then you
If
will go on
contractor
to
filed-
issue
if
the
contractor filed to the rectify the defects, so as a client, they can encase from the retention money. The retention money.
Yes, of course.
Yeah.
If it is okay. So those are the questions what I have prepared for this session based on the key skill areas that is listed under the RACS when you go to the skill checklist. So that area it is listed these things. So we have covered most of them, at least one question each. So if you have something to discuss or any other thing to get clarified, we can do that now. At all, we don't have any further question or clarification or discussions. We may call this as a day. Thank you for joining.
Yeah, thank you.
See
Thank
you all
so
in the
much.
next session. All
Yeah.
the best.
Thank you so much.
Welcome.
Thank you.
Thanks for joining.